much for joining us this evening. If this is your first time on one of my webinars, thank you very much. And if you've been on them before, thank you again for joining us. I'm Sarah Buxton, and I'm a HR and employment solicitor. And you can see on the screen the services that we provide for you. And I am joined by two guests today, who I'm going to let introduce yourself and what you tell us a little bit about what you do. Zoe?
Hiya, yeah, I'm Zoe Close, and I am head of sales for Practice Plan. But previous to that, I've been working in the dental industry 36 years now, so quite a long time. So got lots of practice experience as well, and that's me.
Thank you. Pat?
Hi there, everyone. I'm Pat Langley. I'm a dentist, at least not a wet gloved one anymore. So Appeline is my company, and we provide support to dental practices in all matters relating to regulatory compliance, and of course for the last almost year relating to COVID and how to get through the little nightmare we've been presented with. So thank you for asking me, Sarah. It's a pleasure to be here.
No, thank you. I asked both Zoe and Pat to join me this evening because quite often with the topics that are trending at the moment, there's quite often a compliance element to it, which Pat is best placed to advise on. And also it's really good to hear from Zoe because you do have people and reps out there helping the practices, so you have a really good feel for what's happening day to day in the practices. And so, like I say, if anybody has got any questions, please feel free to take your video off or put it in the chat, and we can have a really fruitful conversation. I'm going to start with the Uber case that's happened, the judgment that we had last week, because I think a lot of people have become a little bit scared about it, and there's lots of misleading information out there. And I think it's important to note that for years, and not just in the dental industry, we've had this whole situation of balancing whether dental associates are really self-employed or not. And how we define whether somebody's really self-employed or not depends on the relationship that you as a dental practice owner have with your associates or self-employed hygienists and therapists. The agreement that you have in place should reflect that relationship. So there's no point having an agreement that is a complete sham, because what the courts will look at is what actually happens in practice. And the Uber case concerned the drivers of the taxis, and they thought they should be classed as workers and therefore have the right to sick pay, holiday pay, and various rights that workers have over self-employed individuals. And the courts will look at the self-employed indicators, and the courts decided that the Uber drivers of the taxis were workers and not self-employed, and that they started working from the moment they switched their app on, because they have a license to perform that work personally. And I think that's really important because it distinguishes from a dental associate where they can send in a locum or a substitute in practice. My concern is obviously if that doesn't happen in practice and we look at people like maybe hygienists or therapists where we don't always give them a right to substitute. Some practices do, but quite often they don't. So I think it's really important that first of all, we do get the status right and that we have the contracts correct. I think what's going to happen with the cause is that the judges are going to look at it, the status slightly different because they've got this case now to rely on. But I don't think there should be anybody who's starts getting too worried about dental associates as long as you use locums. And I think for hygienists and therapists, I've always said in many of my seminars and webinars that they are the ones that concern me the most, because we don't tend to treat them like self-employed persons, and this case may have an effect on them. But if the relationship is one where it is like self-employed, it's not a blanket across the industry, and that's what's worrying me, that people think that it's across the industry. Now all hygienists and therapists have to be employed or workers. That's not the case. It will depend on the individual practice. So Zoe, in your experience in the practices, do you tend to find hygienists and therapists employed, self-employed? What's yours? You mute. Yeah, there we go. We've heard you.
Got there in the end. I think the amount of times that people have said to me this last year, "You're on mute." Yeah, we do find that there is a concern. I know the Uber situation has been discussed, and there's been a lot of chat around socially around it. Yeah, I mean, obviously, you know, before this job, I used to look after a group of dental practices for a corporate company, and I think it's been spoken about since I was probably 16 and went into practice life. I think it's always been the concern for, you know, practice owners and associates. So yeah, I think there's things in there, like you just said, so to protect yourself. And I think, you know, if you've got it in your contracts that you do use locums, but I think the hygienist bit is, you're right. I think we do sometimes forget that they're self-employed, and we tend to sort of treat them more like an employee. So I think it's just being mindful of that.
Yeah, it's interesting because I've got a case at the moment where I'm acting for the practice owners, and their associates have tried or are making a claim against them whilst and trying to claim that basically they're workers, and they are trying to use it on the basis that they have been paid this NHS payment for not working. And why would you do that if they're genuinely self-employed? And this was something that was concerning at the outset. Now, I know HMRC said to the BDA at some point, oh, we're going to turn a blind eye to it, so don't worry about it. But that's not necessarily the same for the Employment Tribunal. And it's hard for practice owners, because what the NHS did is try to control how you treat your self-employed staff, but not in line with the current legislation or the current status. So what it's done is, what we're having to do in this claim is basically say, hang on a minute, we had to do this because we would never have received our NHS payments if we hadn't have acted in this way. And I'm sorry, but we have a business to protect. So everything we knew about being self-employed, we had to pay them, and that goes against the grain of what Employment Tribunal judges look at. So we're hoping with this claim that the tribunal judge, if it gets to that point, will say, hang on a minute, this was a pandemic. You were acting under strict instructions from the NHS, and actually what's happening now are these dental associates are trying to take advantage of the duress you were under, basically. That doesn't mean there was a change in status, but who knows? Really interesting how it's going to unfold, and it's interesting that the NHS didn't think about this when they were saying you must pay your associates in the same way that you've always paid them, because it does have legal implications. So definitely, I mean, Pat, in practice, when you're doing your compliance policies, you will know which policies apply to who within the practice, because you won't want them to be seen to be too controlling over the self-employed staff, because control is all about is the indicator of whether they're self-employed or not.
Yeah, absolutely. Actually, Just before I do that, actually, I'll just share a personal experience I had of when I was clinical director at Oasis, and one of the self-employed associates took Oasis to an employment tribunal, and I had the extraordinarily unpleasant experience of being grilled by the barrister for about 2 hours. And the things that really mattered in this particular case were, as you say, Sarah, right of substitution, but also that the associate had bought his own clinical uniforms. That's incredibly important, and had paid for his own CPD. Mm-hmm. So, you know, I think practice owners should not be paying for the CPD of their associates. They should be paying for that, and also for their clinical uniforms. And in terms of your question regarding compliance, that's a difficult one on similar lines to what you've outlined with the NHS, because the CQC requires everybody who works in a practice to be compliant. And you know, part of being compliant is keeping good clinical records. The GDC requires you to keep good clinical records. So, you know, we have a policy, Appline has a policy on how to keep clinical records and an audit that you can undertake. But at the end of the day, you know, the relationship is then between the principal and the associate, but the associate also has individual personal responsibility. So it's monstrously complicated, actually. But the associate, or everybody who works in the practice, must also be compliant. So the associate has an individual responsibility to be compliant in the eyes of the CQC. The CQC sees self-employed associates as, they think of them as employees, which is unhelpful.
Yeah, I always recall when the CQC legislation was initially introduced, that there are always bits which don't fit neatly together with the with the employment legislation. Yeah. One of the big ones for me is when it was first said, it was CQC were asking for you to ensure that your staff were fit physically and mentally able to do the role. And that was quite concerning for employment lawyers like myself, because we always say, no, you mustn't ask health questionnaires. You mustn't ask health questions or do health questionnaires unless it's intrinsic to the role. And I've seen, because people have taken this, I've seen people who have then put policies or procedures or health questionnaires together, which are not suitable under the employment legislation, and almost to the point that they wouldn't be suitable under compliance. And I can give a really good example of this one. So I've got a client who sent me their health questionnaire that they sent to the staff on induction, and it had things on it like, have you ever suffered from a mental illness? Have you, they asked if they were on the contraceptive pill, and there was things like that where I was thinking, well, that's not intrinsic to the role. So you should, it's not, are you allergic to latex, which you may have to ask. So I just find that was taken out of context for some people, and they thought they could ask anything, because the CQC said we had to find out if they were fit physically and mentally able to do this role. And I think it comes back down to having policies and procedures that are right for your practice.
Very much so. So just simply buying a set of policies that you just blindly follow and put your name on the top, or sometimes not even put your name on the top, that's the road to absolute disaster. I think it has to be very reflective of what is applicable in your practice.
Yeah, very much so. So another case that has happened over the last few weeks, which lots of dental practices have got quite concerned about, and I think it's because there was a lot of publicity about it, and it's a case that we shouldn't worry too much about, but it's about vicarious liability. So there's been a lot of publicity about a case where the practice owners were found to be liable for the actions of the associate in terms of their clinical work. So a practice owner has always been liable for the actions of their associates in an employment situation. And I always give the example of the Christmas party. The associate says something after a few drinks to a dental nurse not very happy. Dental nurse makes a complaint to her practice owner because that's her employer, and the employer is liable for what the associate says at that Christmas party. So it's always been in an employment context, and what's worried people is the fact that now the practice owner could be responsible for the clinical work of the associate, and it was a one-off case. It can't be applied across the board, and it may be changed yet, but also I think this comes down to, firstly, making sure you have the correct insurance in place, and it is maybe you would want to deal with it. I think you need to also look at a positive, that protecting the goodwill of your practice. You may want to deal with it if the associate as it can't be found or has gone off somewhere, and you know, there's reasons why as a practice owner you may want to take charge of a complaint and deal with it. But also I think rather than people changing insurance policies or looking at other policies that may not be relevant to them, there is quite a quick and easy way of dealing with this, and it comes back down to the associate agreement. And what I've been advising my clients to do is, if they're concerned at all, we can put clauses in associate agreements where we actually say that the associate is liable for any claim that is made against the practice owner. So you have a contractual right to then go back to the associate if you end up dealing with a patient complaint. But I think in practice, it's really important that patient complaints are dealt with by the practice owner, and it's not always pushed back onto the associate. And I think that's all about just protecting the goodwill and your business. I mean, Zoe, what advice do you tend to give regarding patient complaints in practice?
Yeah, I mean, when I used to work in practice doing exactly that, we always used to get together as a team, you know, the owner of the business and the associate, just so we was all comfortable with, you know, what was going to be sort of communicated or the next step sort of thing. I think if you just leave it to the associate, I mean, I'm sure that you would want to know what the response is going to be or what the next course of action. And obviously you'll have a complaints policy anyway in place. So I think you want to make sure that that's being followed. But I would always say, you know, just to support each other as well. It's just good to be all in the know, but also just to make sure that you're very comfortable with what is the course of action. But yeah, like you say, I mean, if I suppose if you are the practice, it's just leaving it to the associates, how can you be in control of, you know, it's your, like I say, the goodwill, you know, it's your sort of brand and your sort of, you know, what people are sort of seeing. So you would always want to get involved, I would imagine. I think that is definitely the right advice.
Can I say something on that, Sarah? So the GDC does require dentists to be individually responsible for their complaints, as you know. So I completely agree with what you're both saying, which is that it needs to be a joint effort. You know, I don't think it should just be it shouldn't just be left to the associate, and it shouldn't just be left to the principal, because you can't just leave it to the principal, because if the complaint's against the associate, then the associate, and it goes to the GDC, say, then the GDC requires the dentist to be the associate, to be individually responsible. I think one of the bigger problems is that some of the defence organisations, I had a case recently where a defence organisation wrote what I think was possibly not a very helpful response to the patient. But then again, I don't think the dentist had been entirely honest with the defence organisation. So I think it's a very, very complicated area, and trying to avoid complaints in the first place is the best thing you can possibly do. And also bearing in mind that most complaints are not clinical. Most complaints are about some kind of communication issue, that the patient didn't understand something because it hadn't been properly explained to them. And that's a practice issue, because if things are not being properly communicated to the patients, then that should show up on your complaints tracker as something that keeps happening frequently. So most complaints are not about the clinical treatment as such. They're about something else. And the biggest thing of all that causes a complaint is one dentist criticising another's treatment plans, records. So best to avoid doing that.
Brilliant. I mean, those are definitely my hot HR topics that have been trending over the last week. What are you finding in practice, Zoe, that's been trending for you?
Well, you'd have asked me a couple of weeks ago. It was more trying to get people into work. So it was people that are quite reluctant, staff levels are low in practice when you actually need more because of all the fallow time and all of the checks that you have to do. So it was how to sort of, operate under restricted sort of guidelines, but also encourage people to come back to work, feel safe, but they've got children at home and things like that. So that sort of settled down. I think the main thing now that people are starting to talk about is the vaccines. And what if I've got a team of people, some of them are very reluctant to get the vaccination, should we as a practice insist on that? Can we insist on that? And is there any help for us as employers? So that's trending quite a lot with us at the moment. I'm hearing lots of people are getting vaccines, but there will be some people that are quite reluctant.
Yeah, absolutely. I think it worries me because I think the media does mislead people on the vaccination front. Don't know if any of you have seen Plimco Plumbers in the news. He actually was one of the persons where we looked at self-employed status a few years ago. There was a huge case about whether his plumbers were genuinely self-employed or not, and he's been in the news a lot about how he's going to have this no jab, no job policy. And then when you actually get into the article, it actually starts saying how he's asking his lawyers if he can have this policy, but he won't sack anybody if they don't have a vaccination. So I think, but if you read the headlines, you think, oh, I can have that in my practice too. I can have this mandatory policy where I want people to have this vaccination. And I think it's too early days to be introducing a policy along those lines, because most people are having good reasons as to why they don't want it. So for example, and I know that they have put this to bed, but that people were concerned about whether it did affect fertility at one point. So they were refusing to have the vaccination. And I think if you went down the line of saying, well, it's mandatory in my practice, then that would have a discrimination claim for women, because that would only really affect women. So my advice at the moment is that it can't be mandatory. You can encourage. I think making sure that you have the right information and the correct information, and that is communicated so that they're not reading things in the media and getting the wrong information. But I think also we need to respect the team's confidentiality. And this is a huge issue at the moment that I'm dealing with, because it seems to be that we've forgotten about this. It is a health and it should be confidential. It's something where we need to treat that data, and I'm going to use that word to remind you all about your policies in that regard, carefully, because we shouldn't be telling everybody who's had it and who hasn't had it, or trying to enforce people to have it, because at the moment until the GDC turn around and say it's mandatory for you to be ready to have this vaccination, to be registered, I don't think any court would see it to be proportionate that you make it a term of their contract. And I don't mean just writing it in a contract, I mean trying to force people through policies and procedures into having it. But I think the biggest element that's going to come out of this, if we're not careful as practice owners and managers, is the fact that I come across a lot of people breaching confidentiality. I don't think it's something where there should be a team meeting about it. I don't think it's appropriate. I don't think we should be telling our patients who's had it and who hasn't. I think that opens a can of worms in terms of protecting the individual and your own brand. It comes back down to what kind of message do you want to give. So really, with the vaccinations, it is a very hot topic and it's still ongoing. And I think it's because it's an emotive topic that people feel very strongly about.
Yeah.
Do you have anything to add to that, Pat?
The other thing, Sarah, that we're getting sort of...
Sorry, Zoe, go ahead.
Zoe?
Well, no, I was just going to say it's sort of we're getting all. I mean, the questions we're getting really are all around the vaccinations. However, we are getting still the same sort of questions around if people still don't want to come back to work and put the children in school. Are we allowed to leave them at home? Can we put them back on furlough? Should we be giving them holiday pay? Should we just pay them anyway? What can we do really? So again, it's just managing their practices. It's really quite tough at the moment.
Yeah, I think in respect of that, key dentists are classed as key workers, so they should be able to get their children into school. And I think there is a point where if there are childcare issues, and I think you're right, Zoe, in that a lot of them tend to be my after school club isn't available, so I can get them in till 3 o'clock or 3:30, but then at that point, what do? I need to leave early. And they can put them on furlough if they wish to claim furlough if it's related to a childcare issue. But it just gets to a point where at the end of the day, you've got a business to run, and it's a highly regulated business, hence why Pat's here on the compliance and regulatory side, where you cannot actually run your business without your team, and nobody can keep using the childcare excuse and not look at ways of getting back into work. So if as a practice owner you've compromised and you've tried to help them with their childcare issues, if it's not working for you and there's no end in sight and they're not saying, right, I'm definitely back on the 4th of March when all schools are open, then I think you can start going through some procedure to maybe the relationship has come to an end because they're not part of the team. It's not, I wouldn't jump into it. It's not the first thing you look at, but it does get to a point where that you can't expect to be running a business and paying people's wages for them not to be there. So lots to go through in the first instance, making sure you've looked at all the different options. But I think some people are still hiding behind the childcare issue. I think there's a lot of genuine, but I think people are hiding behind it. And there gets to a point where you need to act and be proactive and do something about it.
I agree. And just to go to continue on the vaccine topic, I think I completely agree with what you say, Sarah, about confidentiality. And I think my guidance would be try and find, if it's a member of staff, try and find out what their objection to it is and see if you can help them with it. And as more and more data comes out and things like the fertility issue hopefully goes away, then hopefully more people will take it. But Sarah's absolutely spot on. Until the GDC makes it a requirement of registration, then you can't enforce it. But I think that, one of Chris Barrow's favourite sayings is that all problems exist in the absence of a good conversation. Have a good conversation, find out what the issues are, and don't say, obviously don't say, oh, for God's sake, that's ridiculous. Listen to the person's concerns, listen properly, and try and help them with their concerns, but don't try and push them into something that they feel very strongly about on the vaccine front.
All right, we've had a message, and it's thank you very much for your question. If anybody else has got any questions, do let us know. It says, if you give your associate a temporary agreement to handle NHS Q4, but they don't wish to sign it, what is the best way to handle this? Well, I probably would parrot just what Pat said, is that we need to find out what the issue is really, and why they're not signing it. But if it's a case of, belt and braces approach is it's always best to get an agreement signed. We like signed agreements because it is quite clear that somebody's read it, well, supposed to have read it, that they've signed the agreement. I'll let you know, lawyers are the worst in the world as well for reading terms and conditions. Lawyers just sign anything, even though we're taught that we should read it.
Say that, Sarah.
Honestly, they just sign anything. We're taught to read everything, but when we're doing it for ourselves. So we do like signed agreements. But if you can't get their agreement to it and they don't have a reason for not signing it, the next step is that in the eyes of the law, they've accepted that agreement because you've given it to them. It's deemed to be accepted because they haven't turned around and said to you, I disagree with this because. So sometimes for a short period of time, such as this Q4 that the NHS have issued up until the end of March, rather than, we're nearly at the end of February now, rather than hitting your head against the brick wall for the next month, it may be worth just leaving it because it's going to change again. But belt and braces approaches, I would always say try and get the agreement signed as best you can. But it's interesting because I'd like to know, but the conversation needs to be why are they not signing that agreement? It's an interesting one. There might be something in there that they don't understand or they're not happy with. But ultimately, if they want to be paid, it's not you dictating how they should be paid, is it? You have to pay them in this certain way because this is how the NHS are telling you to run your business. So they don't, what argument can they have about it? It's just interesting to know what their reason for not signing the agreement would be. But thank you for your question. Pat, what's trending for you then in practice?
Well, something just trended. It's still right to the top of my interest just today, actually, Sarah. So this is a real situation that happened in a real practice today. So this is a patient who previously came to the practice and refused to wear a mask, and came in and refused to pay remotely, said he would only pay with cash, and also handed over a document to the dentist outlining why all vaccines were experimental. So, he clearly has very strong views. Anyway, I helped the practice compose an email because it is a legal requirement to wear a mask. So this is not like a vaccine, it's a legal requirement to wear a mask unless you're exempt for health reasons. Anyway, so I helped the practice compose an email to send to the patient to say, look, we respect your opinions. We understand that this is the way you wish to proceed. This is not something, though, that we can allow in our practice for safety reasons and also because it's a legal requirement to wear a mask. Anyway, patient didn't respond. And then turned up today. Now the practice, the practice had left left themselves a bit vulnerable because they'd left the patient's appointment in the book, I think hoping that he would comply when he came to the practice. Anyway, came to the practice. The principal had known the patient for quite a long time and said to him, X, you need to wear a mask. The patient then said, it's against my religion. And of course, the dentist then felt very concerned that would be discrimination. So went to endless lengths to mitigate the risks, took the patient round the back of the building, in through the back door, so didn't go through the waiting room, into the surgery, didn't discuss it with his nurse first, which personally I think was a mistake. Nurse was immensely upset afterwards and felt that her opinions had been ignored and undervalued because she was unhappy. And actually that the practice, a lot of the people in the practice has been in an area of high transmission, and so a lot of the team have been very nervous. And so really this is quite a conundrum, because I feel actually that I think that it's a very difficult one, because the patient has played the religious, no, not played, he has stated that it's for religious purposes, that he can't wear a mask. And so the dentist is now vulnerable perhaps to discrimination, but the dentist has upset the team because the team feel unsupported and that it wasn't safe, despite the dentist having mitigated the risks to a huge degree. So that's the situation. What would your comments on that be, Sarah?
Yeah, it's an interesting one, because what makes life difficult is the definition of religion or belief. It's a really wide definition, and even pre-COVID, it covered things like you can have a belief in politics, you can have a belief in veganism. It doesn't have to be one of the main 5 religions for it to be covered under that. So we're always alert when people say it's my belief or my religion, because what you don't want is for them to claim that you were treated at a detriment, because then they'd have a discrimination claim. I think in these circumstances, the team have to accept that if the dentist had turned this individual away for not wearing a mask, and he claimed religion and belief, then I think a judge may have a hard time in thinking, well, hang on a minute. He said it was his religion and belief, and he gets in the chair and he takes his mask off anyway. So what difference does it make if he goes around the building and you're all in PPE anyway? And this happened in a case in Scotland, not in England and Wales, where the practice took a very strict interpretation and said you can't come in without a mask. They didn't explore it, and I think that's where they went wrong, to be honest, to the extent that they should have done. He actually was exempt for health reasons, and the judges actually said, well, hang on a minute, he gets in the chair and he takes his mask off anyway. How can that be proportionate response? I think you're always going to have this. And I think the key here is explaining to the team that there will be certain circumstances where we have to allow people in without a mask. And if they are claiming it is some sort of discrimination, then we have to be especially careful. And I can understand why the associate or the dentist in these circumstances have gone, oh, you're mentioning those words, I'm concerned, and I'm going to let you in. So I think the team need to understand that. And I also think there's a difference between offering a service, so saying these are the terms of my service, and also completely rejecting somebody from having that service. So here they've completely bent over backwards to help him to the extent that they've actually allowed him in. And I think that's a difference, because if you have a no mask, no entry policy, that to me is just quite clear. You're going to end up in a situation where you end up with discrimination claims. So I think each case will have to be dealt with in its own merit. And I think you need to explore why people are not wearing masks. And I agree with you, Pat. I think there should have been a conversation beforehand where it was explained to the staff why he was going to be allowed to attend the surgery. But I think we do have to be careful with certain people to make sure that we don't outright reject them from having our services. Also, there's going to be a point, isn't there, where we don't have masks, so we need to get used to that. Well, you know, we need
Let's hope so.
At some point, you know, so we need to get used to the fact that as people become vaccinated, they may relax the rules, and I think people are just very scared at the moment because the information is so misleading.
Yeah, I agree. And I also think that I think possibly the mistake, if any, the dentist did make was not to talk to the team about it beforehand, not wait for them to get upset about it. But when put on the spot, you know, you have to make an instant decision as to what you're going to do.
I think so. And I also think the point to make to the team in these circumstances is that there are going to be people who attend without a mask, because there are people who have health exemptions.
Yeah, absolutely.
So the issue that we've got at the moment is that until somebody brings a case, we don't really know if it is a religion, if it falls into the definition of religion or belief, because it's so wide.
Absolutely. And trouble is, the patient didn't endear himself to the practice because he also told them that he didn't think COVID existed anyway, and it was all a hoax. So you know, so it was massively complicated and probably a lose-lose situation, whatever you do.
I think so, definitely. So, have you had any situations with patients who are not wearing masks come to your attention, or most of your?
Yeah, I think we've had a few cases where people have got the health reasons for not wearing masks, and I think most practices that I've sort of spoken to, or my team have, they've generally, you know, accepted those sort of situations. It's funny actually, because I always think about, you know, what would we have done in my last role sort of thing, and I think there's always going to be that person that is just, as Pat's just suggested, someone that is either just, you know, anti-masks or anti-COVID or whatever. There's lots of different sort of views on things. Sometimes it's just easier in practice. I can understand when you start getting, you know, accused of being discriminatory, you sort of just see the patient just to get rid of the problem, and, you know, you're worried about, you know, what is right or wrong. It must be really hard actually, because I know that I would have had to deal with all that, and it's like Pat just said, you've got to really look into the reasons and investigate it more, and you know, think what is the right or wrong thing to do. But I think just to say no one's allowed in without a mask, then that's even saying people with health exemptions shouldn't be. So I think it is by merit, it's that bespoke sort of guide you would have to take, but it must be really difficult actually.
I think it's quite interesting because it probably, that situation leads into something where a lot of practices are having to deal with the team and their actual well-being in terms of this situation and the pandemic and how it has affected them. And in this situation, I think, especially with the nurse who is very upset about this, I think not only does that take a conversation, but I think we should be looking at her well-being, and, you know, at some point this is going to happen where we get more people without masks and this kind of conversation. And I'm always saying to a lot of my practices, clients at the moment, that we need to be looking at the team now. We've been through all this, and those that have stuck with you and are there and been working hard, and they may be suffering and they can be quiet about it, or they may be the other way where they're complaining a lot. So I'm finding this and what it boils down to is this has been a really hard year for a lot of people, and as an employer there's going to be a lot more emphasis on looking after your staff, not only from a remuneration package or making sure that you pay them correctly and bonuses and stuff, but also looking after their well-being. And I think going forward, the courts will look at, and this was introduced last April, will look at what you've done as a practice owner to support your staff in their well-being and their mental well-being. And I am telling a lot of people, practice managers or practice owners should be taking first aid courses for mental health as well. So not just the physical side of things, we need to be exploring that and making sure that we're equipped as a practice owner and manager. And I think if, for example, what made me think about it is in these circumstances, if the dental nurse is so aggrieved by this, there may be some underlying issue, not only in respect of her safety, but if she's coping very well as a whole, because you see people, don't you, without masks on. So it's part of society that there are always going to be people without masks. So it's just looking into that a little bit deeper. But I'm definitely telling people first aid courses for mental health. If you can definitely start looking into that, and practice manager or practice owner, then that would be really good to help you support your team going forward.
We've actually just been running some, Sarah, with Practice Plan. We've actually just done some for our clients, and it was quite a large uptake actually. And we've decided we're going to run some more in March time and April, because there was such a huge interest. But yeah, it's definitely the right thing to do, because it is an area that I think before COVID was very aware of it, but I think now it's become, you know, a real reality that we need to get more informed. So we've had massive of interest, which is great.
Yeah, somebody's just.
It is great, and it's given me an idea actually. I think you know, we do provide online training. I think we'll create something for our members and anyone else who wants it. That I think we'll create something online that hopefully will help with that.
Oh, absolutely. I think that'd be great, because the thing is that the courts look at, and I'm always looking at protecting my clients from a claim, and especially the discrimination elements of the claim, but they'll look at how they've been treated in practice, and that covers self-employed staff as well as employed. So you have a duty towards both. Somebody's just sent me a message just saying, I've been caused so much stress by mine. I'm on long-term sick and shielding, and my sick pay has been withheld. So I've resigned as it's affecting my health. They've also gone on to say they're an NHS dentist. I mean, I'm really sorry to hear that, because that it shouldn't get to that point. And I think maybe if you can look on a positive, is that they probably weren't the right practice for you, if they're withholding your sick pay, and they've caused you so much stress that you're probably better off in another team anyway, that are better for you. But definitely, they said they've been there an awful long time, since 2006 as well. But I think what's happening, and this isn't an excuse for the practice owner, but it's been such a year of turbulence, especially for an NHS practice, because they don't know what they've had to do, what they've been paying. It's the guidance has been woolly. We've been having to wait, especially in England, for guidance. So it's been really difficult. And then I think that's having an effect on the whole team. But that's no excuse for withholding your sick pay, if that belongs to you. The NHS sick pay, if that's what you're talking about, belongs to the associate, and it usually says that in the contract. So if it wasn't too much stress for you, because I think you would be able to have a claim against your practice owner for that. The problem is, if you're not feeling very well and you're stressed, legal proceedings can be even more stressful and can really affect your health. So sometimes it's my advice, if you're not feeling very well and it's got to that point, it's maybe just worth cutting your losses, because what you don't want is something to make you worse. Even if legal proceedings, you've got the best case in the world, if you're not up for it, it's not worth going down that route. Somebody's just said they're so fearful of attracting a complaint from a patient that they just seem to do what they like a lot of the time. And I think, do you think that's probably down to, I mean, I'm a highly regulated individual as well. I think, you know, I'm regulated by the Solicitor Regulation Authority and the Law Society. I can be struck off. I can be taken to a tribunal, and I do understand that as a professional, you do get very worried about complaints and what people are saying to you. So I do empathize in that regard, but I also think that there's a way of dealing with complaints that protect the practice without you having to worry. And even if it did get to the GDC or the CQC, that you'd have done the right thing to protect yourself. And I think sometimes rather than giving in, it's just better to take advice from the right source.
Yeah, I agree with that, Sarah. I think practices do sometimes make some mistakes, though. You know, one of the things that I never ever want to hear is, could you put your complaint in writing? Once the complaint's in writing, it's an actual proper thing. Try really hard to resolve it in the practice without it ever going into writing. I think I would say, plus also, I think that there can often be a terrible reluctance to avoid using the word sorry, when actually, you know, what patients want is always an apology, an acknowledgement that something hasn't gone according to plan, and usually they want to know the same thing's not going to happen to them or anyone else again. So, and the defence organisations all talk a lot about this. You know, saying I'm so sorry such and such has happened doesn't mean I'm sorry I've made a terrible mistake. It means I'm sorry that this thing has happened, because you know, practicing dentistry is not an exact science, and things do go wrong. And when they go wrong, our duty of candour has to be that we acknowledge it's gone wrong, we tell the truth about what's gone wrong, we apologise, and then we do everything we can to try and make sure it doesn't happen again. So some of those little things, like, you know, a reluctance to say sorry, sometimes a reluctance to give the patient their money back. You know, if a patient's really unhappy with the service, give them their money back, and just give it back as a gesture of goodwill. And I know that's a painful thing to do, but sometimes it's a better thing than having it go all the way to the GDC, who are then going to drag it out over 18 months.
Yeah, definitely. Honestly, Pat, in my last role, I saw dentists sweat for weeks, if not months, because they'd dug their heels in. And when they reflected, they said, if only I'd have sort of, you know, dealt with this differently, or sort of just accepted that actually there was some sort of, you know, something could have been done differently. And like you say, it's not admitting any liability. It's just saying, on this occasion, as a gesture of goodwill, because, you know, I've sat there and had to counsel dentists that have been dealing, you know, in front of a complaint, and it's not easy for me to watch. So I agree. Sometimes it's, like you said, right at the beginning, it's about making sure that right at the beginning you sort of deal with it correctly, and there is ways of actually having a really easy outcome quite early on.
Yeah, absolutely.
And I would say if you followed that,
I sort of feel that they, you know, it's hard.
And I would also say if you followed that into your employment relationships or your relationship with the associate, you can stop a lot of disputes. So it's again, it's a same situation where don't ask an employee to put something in writing, because then it becomes a formal grievance and then it escalates and so on. If you can deal with it informally, and sometimes you have to apologise for things that have happened, or it may be, let's get two people together and sort out, and I understand your version of events, nobody's lying, but this is, let's move forward. That also can solve a lot of problems, because my job is to ensure that things don't escalate. So even though we obviously know the disciplinary and grievance procedures, or the what happens in an employment tribunal, for most of my clients, my day-to-day is stopping things from escalating into that formal situation and dealing with it. And saying sorry is actually one of the easiest ways to deal with an employment issue, even if the employee is not right. You can be sorry that something's happened on that occasion in their eyes, so to speak.
Absolutely. And I think there's another complete no-no as well, which is, I'm sorry, but. You know, don't ever use the word but, because I'm sorry, but means I'm actually not sorry at all.
So I've got a question. You said ideally associates should pay for their own CPD. They organise medical emergency CPD as a practice, so that tends to be done in practices as the team. Should we ask the associate to join, or should we ask them to pay for part of it themselves to prove their self-employed status? There are certain courses that you will want to ensure that the associate undertakes. And you can either ask for them to pay towards it, or you can say it's a contractual obligation on them to sort it out and make sure they've done it, and they've got to inform you once they've done it. I don't think there's anything wrong with having a team one. I think in the days when you could get the team together and shut the practice and do all your training together, I think it can actually be quite nice for morale. So
I think I think that's different from paying for all an associate CPD in, you know, to go on an Invisalign course, or to go, you know, and implant training, that sort of thing. I think that's the sort of thing I meant. I think, you know, having team training together, absolutely fine, and that should be paid for by the practice. Completely agree.
I've got a few bits that I just wanted to say, because there's just some changes in the law. So as ever, keeping us on our toes, employment legislation is changing. There is the budget coming up next week, and who knows what changes are going to be in there. There's lots of rumours flying around that we're stuck with furlough for a bit longer, which may be a good thing. So we'll see what happens next week. We have lots of, I've got lots of webinars booked in for next week. So if you're interested in the consequences of the budget with you in your practice, then have a look on social media and sign up to that. But there are, 1st of April, the national minimum wage is increasing. Do tend to find that most people in practice tend to be above national minimum wage, but if you do have anyone, then just make sure that you pay them accordingly. They will be introducing pregnancy protection this year, so just keep your eye out for what's happening. I think there's still a few redundancies going on. I don't know if you're noticing that, Zoe, Pat, in practice, but there are still redundancies being made. I'm still advising on them. I think it may be a good opportunity, if you haven't done so already, if you reassess and have a look at the team and whether they're right for you, and redundancy may be a reason to bring employment to an end. It seems to be accepted by the employee. So there's still redundancies, but what they're looking at the moment is, if you have somebody on maternity leave, at the moment, they are protected from redundancy. So if you have a group of dental nurses and you have 5 dental nurses and you only need 3, so 2 are going to be made redundant. If one of them is on maternity, they will automatically get the job. So that was a piece of legislation brought in the 80s, where I think lots of women must have been made redundant just because of the fact that they were on maternity. So I don't know how I feel about it, because I think the right person should get the job, not just somebody who's just because they're on maternity should get it. So, but for some reason they're extending that. And so what they're looking at is protecting somebody from redundancy from the moment they actually tell you they're pregnant, during their maternity, and then when they return from maternity. And we're waiting for a date as to when that should be introduced. So just keep an eye out for that, because I do think that has a huge impact on businesses. And also this year, they are looking at bringing in neonatal leave and pay. We'll see what happens and what they're going to introduce in those circumstances. But just to give you a few changes that are up and coming. But I think the most important ones for practices at the moment, for me, it's definitely reviewing your self-employed agreements, to make sure that they are in line with the Uber decision, and that you do follow those, and that if you are concerned about vicarious liability, we can draft clauses in your agreements to protect you from that. So those are the things that I think as practice owners and managers you need to be reviewing and looking at the moment. Pat, Zoe, what do you think, just to finish us off, what that practice owners need to and managers need to be concerned at the moment and looking at?
After you, Zoe. Oh, Zoe.
I'm mute.
Sorry, I lost.
Yeah,
I
we
lost a little
you.
bit of that. Sorry, I think my internet dropped.
We're just saying what for me. So
Sorry.
I think practices need to just be looking at the self-employed agreements at the moment, and just making sure that they are updated with the current legislation and are fit for purpose. So what would your advice to practices be? What should they be looking at the moment?
I think all of what you've just said, Sarah, I think that's relevant all the time, not just now. I think that's sort of reflective of practice life. And I think that, getting things in order, it's really difficult in practice. And I do empathise. And I know, what you say and what Pat's saying, it's so true that we do need to sort of get our ducks in order sort of thing. But practice life is so fraught that sometimes it can be the last thing that people do. But it is worth making time, because it can come back and bite you in the bum, and I've experienced that. It's just making sure that you have got things like this correctly in place, so you don't have these worries and concerns. But from my perspective on what people should be doing at the moment is all the worries and concerns that my team get asked. We won't have all the answers for you, because things are changing so quickly. I mean, we've all literally had to think on our feet, including yourselves. And it is, get the expertise advice, speak to people like yourself and Pat, and people that can help you and hold your hand through some of the concerns. It's never too late to get really organised and get things in place. Because, just asking the questions as they arise, but not really getting the clear, straight advice, I think, again, it's just leaving you very vulnerable, and it just causes sleepless nights. So, hopefully, if anything, COVID sort of, again, highlighted the fact that, we need to make sure we can be as organised as we can and have things in place.
Yeah.
Thank you.
I agree with all of that. And I also, I echo what Zoe says, is that, get expert advice. And, if you've got an HR and employment law issue, ask an expert, ask Sarah. This is what we do. This is how we spend our lives, trying to help and support. I think what I think practice owners and should be thinking about at the moment is, as we go through the vaccination program and more people have got vaccinated, and it opens up more and more, just be really careful that you do still continue to follow the protocols, the strict SOPs, for the protection of everyone until we're in a much better place. I don't want to sound like Boris, all gloomy, and thankfully, although my hair looks almost as bad as Boris's, we're not quite there yet. But I think everybody's looking forward to the time when things are going to change, but let's not blow this. You know, I'm still hearing from practices that there's been a mask wearing breach, and you're going to think I've got some kind of thing about masks. I haven't, but that is where it usually falls down in a practice, that somebody inadvertently doesn't wear a mask they should have done, and then you've got an infection going on in the practice. So don't drop your guard. Keep following the protocols until we're in a much better place. We can all get to this better place together, and then hopefully, as you say, the mask wearing can reduce. But I do think also just be prepared for that. We're probably never going back to where we were before in dental practices. I think some things will stay forever. So things like the need for better ventilation, that's going to be a requirement forever.
That's brilliant. Thank you very much. Thank you. Thank you so much for everybody that's attended this evening. We're all, I think I speak for all of us when we're all happy to help our clients or potential clients. So if there are any questions that you have and we haven't answered, then drop us an email. My email is sarah.buxton@fta-law.com. Pat, it's your email.
Pat.langley@Apolline, AP1P02Ls INE.UK.com. And important, it's only 1P and 2 Ls.
And Zoe, if people need any more information about practice plan and the type of support you provide.
Yeah, definitely happy to help. My email address is zoe.close, CLOSE, @practiceplan.co.uk.
Thank you so much. Thank you, Pat and Zoe, for joining me this evening. It's been great. And thank you to everybody that's attended. Like I say, if you do need any more information and we haven't had the opportunity to answer your question, or you think of something later on this evening, you think, oh, we should have asked that question, do drop us an email because we're all happy to help. But thank you very much, and we'll be in touch soon. So thank you.